Long-term disability insurance policies, well, as we've mentioned in some of our video blogs before, there basically are two ways in which you can get a long-term disability policy. One, which commonly happens, is your employer provides it as a fringe benefit, as one of the benefits you get from employment. The other way you can obtain a policy is through going out and buying it yourself from an insurance agent. Let's talk about the ones that are provided through your employment. They are governed by ERISA. ERISA is an acronym that stands for Employee Retirement Income Security Act. It was a program that was put together by Congress years ago, back in the 80s, as a result of a lot of abuses that were taking place in pension programs. It turned out that a lot of people that thought they were covered by pension programs, when it came time for them to recover their pension, to receive their pension, actually were receiving nothing. Congress passed the ERISA program in order to deal with that. The problem was Congress rushed this act through, and as a result, it was very badly written. Today, it is now applied to all the benefits that an employer may provide. Obviously, it covers long-term disability, it covers any kind of an insurance policy, life insurance, it covers medical benefits, it covers a variety of things that an employer can provide as a benefit. It's a very unique law. There are very specific provisions that restrict what you can do when you're bringing claim under an ERISA-covered policy. Okay, now one of the things that may happen when you have a policy provided through an employer is that the insurance company will turn down benefits. They may turn down benefits initially when you make the application. They may turn down benefits later after they've paid several years. When they do that, they're going to get a letter. The letter is going to point out they are denying benefits, and they'll state why they're denying benefits, but at the end of the letter they will say you have 6 months in which to appeal the decision that was made by the insurance company to cut off your benefits. Well, a lot of people look at that and they say, oh, well, that's no big deal. Let me just write them a letter because they've been paying benefits all this time. Things haven't changed. I'll just write them a letter. Well, people don't realize that possibly things have very much changed under their contract because a lot of policies move from any occupation to an own occupation after 2 years, some after 3 years, some after only a year. Point being that the standard of review changes and the insurance company may turn down your benefits at that point in time. Have 6 months to appeal. Now, when you appeal, this is going to be your one and only time to appeal. And when you appeal, you need to write a comprehensive letter that points out all the reasons you're disabled, and you need to support that appeal with all the medical records, the tests, and everything else that your doctors have put together that show you are disabled. Because again, this is your one and only opportunity to submit information to the insurance company. And let me emphasize this again. If your case is turned down by the insurance company again, which generally happens after you appeal, then your next step is going to federal court because it's a federal law, ERISA. You wind up in federal court, and there you can't submit anything further. You can't call witnesses. The judge can't get any additional information. You're restricted to what you put into that appeal because that appeal goes into the claims file. The claims file is the only information, is the only evidence that the judge will see. So your one and only chance to get information before the court is long before you ever go to court, and that's when you have this opportunity to appeal, which happens when you are turned down for benefits. Now, in our law firm, we submit on behalf of clients all kinds of information. We submit medical records from the doctors. We submit statements from people who are witnesses to the person who has the disability. We submit videotapes of the person who is injured or, importantly, disabled. They might be suffering a disease in addition to an injury, or it might be a combination of both, or it might be just a disease or an injury. We submit videotapes of their doctors. We put all of that stuff into the claims file through submitting it to the insurance company as part of the appeal. This appeal is so terribly important. Okay, now once again, this ERISA law applies to those policies that are provided through your employment. Okay, now if you have any questions about this, we have additional information posted on long-term disability claims. Also, there are various attorneys that work in this area. It's a very specialized area. Do consult because the rights you have are very restricted under ERISA. You need to exercise those rights very carefully. Okay, we bring you this as we bring you all these video blogs dealing with long-term disability so you understand how this all works. I'm David Allen.